Greetings, Dr. Tamara. My name is Ryan Mohammad Riaz. We are Group 19, and today we will explore the theories applied by the courts to ensure that the executive operates both effectively and within the law. In particular, our discussion will focus on which administrative law theory is most effective in protecting refugee rights under the UK law. Refugee protection is a critical issue, requiring the courts to strike a delicate balance between upholding the rule of law and allowing the executive to respond to complex challenges such as national security, resources, and public interest. Furthermore, we will examine how these theories ensure a balanced system of governance, providing accountability while empowering public bodies to operate efficiently. By the end, we will share our perspective on which of these theories best safeguards refugee rights without overburdening the executive. Before dwelling into the specifics, it's important to understand the foundation of judicial oversight, judicial review. Judicial review represents the process through which the courts assess and control the exercise of governmental power. It ensures that public authorities entrusted with lawmaking or administrative duties do not exceed the powers conferred upon them. In essence, the courts ask whether the body in question has acted within the legal authority or has overstepped its bounds, and whether the decision-making process adhered to the principles of natural justice, such as fairness, impartiality, and reasonableness. For example, consider the landmark case of Padfield and Minister for Agriculture, Fisheries and Food 1968. Under the Agricultural Marketing Act 1958, farmers complained that the Milk Marketing Board was unfairly fixing prices. When the minister refused to refer their complaint to a committee of investigation, the farmers challenged this decision. The House of Lords ultimately ruled that while the minister could not refuse the complaints without justification, demonstrating the court's critical role in preventing public authorities from abusing discretionary power. While the ruling did not fully resolve the farmers' concerns, it sets an important precedent that public bodies must act reasonably and within the scope of their powers. This principle is especially relevant when considering refugee rights. Refugees are among the most vulnerable groups in society, often fleeing persecution and conflict. They rely on governments to process asylum applications fairly, humanely, and in accordance with international obligations, such as the 1951 Refugee Convention. However, the governments also face significant challenges in managing immigration policies, such as concerns about resources allocation, national security, and the risk of opening floodgates. To navigate these complexities, the courts apply three main theories of administrative law: the red light theory, the green light theory, and the amber light theory. Each theory reflects a different approach to balancing judicial oversight with executive flexibility. The red light theory emphasizes strict judicial intervention to prevent abuses of power and ensure that the public authorities act within the limits of the law. The green light theory, on the other hand, prioritizes the executive's ability to function effectively with minimal judicial interference. The amber light theory seeks to strike a middle ground, allowing courts to intervene only when it's absolutely necessary, while otherwise permitting the executive sufficient flexibility to act. These theories help ensure that refugee rights are protected from abuse of power, that authorities are not excessively hindered by judicial intervention, and that a balance is maintained between operational flexibility and accountability. In this presentation, we will dwell deeper into these theories and assess how they apply to refugee protection under UK law, and discuss which theory we believe is the most effective in safeguarding the rights of refugees. With that, I will now pass it on to the rest of my group members to begin the detailed analysis.
Greetings, Dr. Tamara. My name is Fatin Nabila. So now I will be explaining the first theory of the traffic light theories of administrative law, which is the red light theory. Historically, when the Industrial Revolution began in the 19th century, English laissez-faire ideology promoted this philosophy, which may have political roots. The primary goal of this approach was to prevent the government from intervening into numerous matters. The underlying principle is that states should not be trusted and that granting the government more authority equates to the destruction of human freedom. For this reason, the Columbia Journal of Law anticipates that courts will find answers wherever and to the best of our capabilities. Courts' law will once again be given prominence over all other issues that are secondary. Next, according to A.B. Dicey, he emphasizes that judicial control, which refers to the court's authority to limit administrative actions within the bounds of law, is the term used to describe the authority that courts produce over the administration. The red light theory aligns with the concept of self-correcting democracy, which emphasizes the importance of the rule of law. It also refers to a harm citizens' legal right to challenge an unlawful administrative action in court. Judicial monitoring of the administration serves the dual purposes of ensuring checks and balances between the different branches of government and safeguarding people's freedom and liberties by verifying the legality of administrative activities. Regular judicial review improves accountability and openness while restraining any tendency towards administrative excess. The Red Light scholars also believe that the judiciary has its own standards of freedom and fairness and can be trusted to examine the lawfulness of executive actions. According to this view, judges keep a tight eye on executive power, narrowing in on clearly legal bounds and keeping to what the law contains. Moreover, it is essential to establish a balance between the safeguarding of refugees in the UK. The Red Light theory offers an organized method for getting the necessity to protect refugees, ensure obedience with international responsibilities such as the 1951 Refugee Convention and the European Convention on Human Rights (ECHR), which provide refugee protection and forbid deportation. According to this theory, they serve as a red light that guarantees that the government does not surpass its authority or implement policies that disproportionately violate the rights of refugees. As demonstrated in the 1984 case of RV Home Secretary ex parte Kalwaja, two individuals were held as illegal entrants after acquiring permission to enter the UK through accused fraud or deceit. The House of Lords debated a number of topics including the standard of judicial review in this situation. The House of Lords also concluded that the court might replace the immigration officer's judgment regarding whether a person was an illegal entrant with its own. It is up to the court to determine if the immigration officer's belief was supported by enough evidence. Next, in the case of EV Secretary of State for the Home Department 2004, it is a case that emphasizes greatly on the advanced concept of error of fact as an independent argument that was used in connection with the question of whether the error was established by new evidence. The House of Lords decided the appeal was allowed. In a legal appeal, an error of fact that results in unfairness is a distinct basis of review. The case clearly outlined the standards by which the court must evaluate a judgment of factual error that results in the inequality. Also, courts preserve the balance between defending national interests and assisting refugees by addressing the floodgates issue with evidence, proportionality, and justice. Measures that proportionate is such that courts carefully consider whether restriction on refugee rights are appropriate given the concerns. Judicial scrutiny is unlikely to uphold excessive measures that disproportionately hurt refugees. Other than that, instead of adopting general rules that sacrifice equity in favor of simplicity, refugee applications must be evaluated on individual circumstances or procedural unfairness.
Thank you, Fatin, for your valuable insight of red light theory. My name is Jamila Alina binti Zaina Azam 0371127, and I am going to elaborate on the challenges of applying the red light theory. Despite the main purpose of preventing the government from overpowering an administration, this theory creates conflict because it relies heavily on judicial review. This means that if government decisions violate legal boundaries, the courts can overrule them as illegal or invalid. The main assumption behind this theory is that when public bodies or executive authorities overstep their powers, the judiciary serves as a deterrent. This is due to the fact that unrestricted bureaucratic and executive power of the state endangers the liberty of all individuals. As a result, judicial control is necessary within a nation's political system. The red light theorists, without a doubt, think that the judiciary has unique standards of independence and impartiality that can be used to assess the lawfulness of executive action. As a result, some people may believe that it is an effective method for checking and balancing an administration. As a consequence, the red light theory doubts administrative discretion and places minimal emphasis on the legislative branch to limit the executive power. This means that the idea does not place much trust in government to self-regulate or in parliament for supervising the executive. Instead, it places practically all of its trust on the courts to operate as a check, making the judiciary the main body of accountability. Besides that, the theory comes off as rigid. The theory highlights that all government initiatives must conform exactly to the wording of the law at hand. It does not leave much space for criticism or flexibility, even if bending the rules somewhat may result in better outcomes. Apart from being firm, since the approach relies on courts to remedy the government's misconduct after, it is more reactive than proactive. This implies that it frequently waits for the mistakes to emerge before taking an action, rather than allowing the government to have the liberty to prevent problems through reactive policy. A case mentioned by Fatin, R.V. Home Secretary, ex parte, Kawaja, 1984. This case demonstrates how strict use of judicial review prohibited the Home Secretary from acting without a legal basis, demonstrating that the red light theory's reliance on the courts to guarantee government's action are legal and fall within the limits. Because of its rigidity and reliance on the judicial review, I concluded that the red light theory is only partially suitable to running a nation. It is important to administer a country in a balanced and pragmatic manner.
Greetings, Dr. Tamara. My name is Divya, and today I will be talking about the green light theory. The green light theory draws attention to the possible problems that arise when authority is concentrated in the hands of one individual. It advises that the government adopt a balanced, absolutist approach in encouraging cooperation and optimizing society well-being, and it endorses the notion that communal rights should take precedence over individual rights. This theory, which emphasizes a functionalist and upbeat view of governance, offers an alternate viewpoint to the red light theory. Stott and Felix, 1997, contend that the green light theory, which draws inspirations from theories like John Stuart Plant and Jeremy Bentham, is consistent with utilitarian principles, which place an emphasis on deeds that promote the well-being of society as a whole. The approach views courts as potential roadblocks to administrative progress and seeks to limit the influence of the judiciary on administrative processes. In Meadow and the Minister for Justice, Equality and Law Reform, these concerns are evident as the court displayed reluctance to interfere by narrowly interpreting the scope of judicial review. However, the green light approach is also reflected in cases where courts show deference to avoid obstructing administrative processes. For instance, in cases involving national security, such as Council of Civil Service Unions and Minister for the Civil Service, the House of Lords ruled that certain executive decisions are not subject to judicial review. This established a precedent that the applicability of judicial review depends on the nature of executive power. The green light theory emphasizes that the judiciary should support the effective functioning of governments while ensuring adherence to international commitments such as the 1951 Refugee Convention. This approach guarantees that refugee policies uphold principles like non-refoulement, which protects individuals from being returned to countries where they may face persecution. Furthermore, in refugee cases, courts applying the green light approach often use proportionality reviews to ensure administrative decisions are both fair and balanced. This approach safeguards individual rights while enabling governments to address critical issues such as national security and resource management. By applying proportionality principles, the judiciary ensures that refugee rights are not unduly compromised for broader policy objectives.
Hi, thank you Divya for the elaboration on green light theories. My name is Mama Adam bin Rusaini and my student ID is 0370707. So I will talk about the amber light theory. The administrative law is shaped by various theories that provide a framework for understanding the role of courts and public authorities. Among these, the amber light theory seeks to bridge the gap between two opposing perspectives, the red light theory and the green light theory. While the red light theory focuses on restricting administrative power and maintaining judicial oversight to protect individual rights, the green light theory emphasizes the necessity of administrative discretion for efficient governance. Amber light theory, in contrast, attempts to harmonize these opposing approaches, creating a balanced system where administrative actions are both effective and accountable. Amber light theory advocates for a middle ground that respects the discretion of administrative bodies while ensuring their action adhere to principles of fairness, proportionality, and justice. This theory emphasizes that administrative decisions must not only achieve legitimate aims but also protect individual rights and avoid unnecessary or excessive harm. The judiciary plays an essential role in this framework, acting as a mediator to ensure that administrative action maintain this balance. So, the application of amber light theory to refugees issues. Refugee policies often involve complex administrative decisions that must balance humanitarian consideration with national security and resource constraint. Amber-Light theories is particularly relevant in this context because it focuses on finding compromise between the strict limitation of the red light theory and the unchecked discretion allowed by the green light theory. So judicial oversight ensure that administrative decisions affecting refugees comply with fundamental rights such as the right to life, non-discrimination and due process. Courts can scrutinize policies that may disproportionately affect refugees, ensuring that they are fair and justified. Furthermore, Amber-Light theory supports the creation of clear and balanced guidelines for handling refugees issues. These guidelines should address both the humanitarian needs of refugees and the administrative challenge of integrating them into host countries. For example, courts can review whether decisions to detain or deport refugees are reasonable, proportional, and based on clear evidence. Next, in the case of Bank Mellat and Her Majesty Treasury 2013, in this case, it provides a clear illustration of Amber-Light theory in practice. Bank Mellat and Iranian Bank was subjected to financial sanction under the Financial Restriction Order 2009, which was issued by the UK Treasury. The Treasury argued that the sanctions were necessary to mitigate risks associated with Iran's nuclear program. The sanction effectively barred Bank Mellat from the UK financial market, severely damaging its operation. Thank you.
So, thank you Adam. My name is Muhammad Aziz Shairan bin Nora Zulkifli and my student ID is 0371215. So, for my part, I will further elaborate on the case that Adam explained and also add some additional info for Amber-Light theory. So, the key issues in the recent case included whether the sanctions were proportionate and necessary to achieve the legitimate aim of protecting national security, whether the sanctions were procedurally fair, and whether the decision was discriminatory as other Iranian banks were not similarly targeted. The UK Supreme Court ruled in the favour of Bank Mellat by a narrow majority, finding that the Treasury's actions were disproportionate and procedurally flawed. The court concluded that the sanctions unfairly singled out Bank Mellat without sufficient justification and that the Treasury had not demonstrated by targeting Bank Mellat specifically was necessary to achieve its objective of combating nuclear proliferation. The court also applied a proportionality test to assess whether the sanctions were excessive in relation to their aims. The court determined that less restrictive measures could have been adopted to achieve the same objective. While the court recognized the Treasury's discretion in matters of national security, it emphasized that such discretion must be exercised responsibly and in accordance with legal principles. This case reflects the Amber-Light theory's balanced approach, which seeks to harmonize administrative discretion with accountability. Other than that, we can also see this theory be applied in the case of R and Secretary of State of Home Department, ex parte Daily, 2001, UKHL 26. Another case that exemplifies the Amber-Light theory, which is David Daly, a prisoner, challenged a Home Office policy allowing prison officers to search inmates' cells in their absence, including inspecting confidential legal correspondence. Daly argued that this policy violated his right to private communication with his solicitor as protected under Article 8 of the European Convention on Human Rights, ECHR. The key issues in this case were whether the policy was proportionate to the legitimate aim of maintaining prison security and whether the policy unjustifiably infringed on prisoners' fundamental rights. The House of Lords held that the policy was unlawful because it violated Daly's fundamental right To confidentiality in legal correspondence, the court applied the principle of proportionality, concluding that the blanket policy went further than necessary to achieve its security objective. The court also found that while security concerns justified some restrictions, the blanket nature of the policy was disproportionate. Alternative measures, such as supervised searches, could have achieved the same objective without infringing on fundamental rights. These decisions illustrates the Amberlight theory's approach of balancing the need for administrative efficiency with the protection of individual rights, ensuring fairness and proportionality in governance. To add more to the theory, the Amberlight theory provides a harmonious framework for addressing complex administrative issues, including those involving refugees and national security. By combining the strengths of both the red and green light theories, Amberlight theory ensures that administrative decisions are effective, fair, and accountable. The cases of Bank Melati and Ex parte Daily highlights how courts apply this theory to strike a balance between administrative discretion and the protection of individual rights. These theories emphasize on proportionality, fairness, and judicial oversight, makes it a vital tool for navigating the challenges of modern administrative law. It also ensures that public authorities act responsibly while respecting the rule of law, creating a system that protects both individual rights and the public interest. So that is all from me. Thank you.
In conclusion, the red light theory is crucial for safeguarding individual rights, emphasizing the need for a firm check on executive power. It protects citizens by allowing them to challenge unlawful administrative actions, ensuring accountability and adherence to the rule of law. Conversely, the green light theory adopts a more flexible approach, focusing on the effective functioning of government, particularly in matters of national interest and security. It recognizes the importance of operational efficiency and the need for authorities to act decisively for the greater good. However, as we analyze the benefits and limitations of both red and green light theories, it becomes clear that a more balanced approach is needed. This is where amber light theory comes into play. The amber light theory seeks to harmonize the rigid oversight of the red light theory with the flexibility of green light theory. It acknowledges that while transparency and justice are essential, too much rigidity can hinder effective governance, and excessive leniency can lead to abuses of power. By adopting the amber light theory, we can establish a framework that promotes proportionality and fairness in administrative actions, especially concerning the rights of vulnerable populations such as refugees. This theory allows for a nuanced examination of governmental decisions, ensuring that individual rights are protected while still enabling necessary governmental functions. It is evident that the goal of this theory is to safeguard a particular vision of human rights. In our view, the amber light theory is the optimal approach for ensuring that executive actions remain within legal constraints while balancing the demands of justice with the need for efficient governance. By creating a more equitable administrative law framework that prioritizes both individual rights and operational effectiveness, we can create a system that serves all individuals within the society, including refugees.